So today, all right. So today we're kind of providing a pretty narrow scope. We're not giving you the full collective bargaining 101 class. Okay, we might do that another day. But today is really kind of, we are going to give you the law and explain some of the law to you because we're lawyers and we can't help ourselves. But more so what we're focused on is what were the things that we saw from the union side that could have been done better from the employers. And these are things that we try and implement every day in the work that we do. So gathering a little bit more perspective from what those people across from you at the table might be doing. I assume probably not a lot of you have negotiated on behalf of the unions. So you're really familiar with the employer side of the negotiating process, but maybe not as familiar with kind of what the ins and outs of what the unions are doing, what the unions might be thinking. So that's really our goal today, is to kind of give you some insight there. Okay, so let's go ahead and we'll go to the next slide. So this is really just some things to keep in mind as you're in these negotiating sessions, in things that might be swaying or influencing the union's side. So one is obviously there's a lot of pressure on these bargaining teams. The membership selects these individuals to represent them to negotiate a good contract for them. And whatever a good contract is, reasonable minds can differ, but that's the hope. So when you're speaking to these bargaining teams, you have to think of them that they're really there and they're feeling that pressure of being the voice for their entire group, whether it's 10, 20, 100, 500 other individuals. So they're certainly feeling that pressure. Secondly, there's always going to be some high expectations going into these things. Kevin, give me an example. Like, what are some of the sources of where these high expectations might be coming from that you've observed?
So just a specific example on that is you have different units in different locations, and sometimes they have completely different contract setups. Probably the best example would be a unit that has interest arbitration, as in they actually get to arbitrate their contract, and at the end of the day, the arbitrator pops out what the new terms are going to be, versus a more standard model wherein bargaining must be done, but at the end of the day, the employer retains the right to impose a contract after going through impasse procedures. So the power dynamics are completely flipped in both of those situations. And so a conversation that one employee might have with another employee in a different unit, they may actually be operating on completely different playing fields. And there's variations and shades of that as well in between them. And then, of course, the other thing is one employee is talking to another employee. It may be lacking a very important context. What were the previous raises the year before, the round in contract negotiations before? What were some very specific financial pressures that were on that department or not on that department that they're talking to? So they come in with some of these expectations and ideas of how bargaining is going to go, most especially if they haven't done it themselves beforehand. One of the things that I, frankly, myself found most illuminating when I switched over from union to management side was there's not an awareness that after a tentative agreement is reached, the bargaining team for the union has to go back and sell this to the membership to get a ratification vote. And they might as well be wearing a flak jacket while they're doing that. And you know, having actually been in some of those meetings before, I mean, it is amazing how personal that gets. And how you've sold us out, all these various assorted things. So when they're trying to really push things at the bargaining table, they need to get to a point where they can sell it to their own membership. I think part of the deal making back and forth is helping them make that sell, because at the end of the day, that's what's going to get the contract ratified. You need to help them understand how exactly there are benefits to them in the contract and how exactly they can explain that to their membership. Again, understanding there's always going to be a percentage of persons that are going to feel as though they've been sold out, things were not as good because look what happened to Department X, and that these people haven't done a good job on a bargaining team. I've heard it described this way before, and I wholeheartedly agree. Being a bargaining unit representative is a very thankless job. There's a lot of flack that comes in with it. It's a tough job to do. A lot of people switch out because of that various assorted reason, and you end up with, that exact reason, and you end up with different faces on a different round of bargaining.
Yeah. So next would be just kind of that general feeling of being wrong or underappreciated. What happens at that bargaining table, a lot of the times, the bargaining team is going to see as a reflection on the work that they do. And it's very difficult to get them out of that mindset. But Ian, did you ever deal with a group that felt underappreciated or not, or wronged in some way?
Yes.
Let me ask it a better way. Did you ever deal with a group that did not feel wronged or underappreciated in some way?
No, and it's all relative, of course. You know, I think taking 2 steps back, it's important to remember that the North Star when you're bargaining in the public sector is what do other employees who are performing similar services at comparable public agencies, what do they receive? And those are legally loaded terms, and everybody has an opinion about who their comps should be, right? If you're here in Sacramento, oftentimes, you know, management side firms would want us to compare to jurisdictions in the Central Valley Corridor, San Joaquin or what have you. Whereas, you know, you might want to benchmark against San Francisco, and is either one appropriate? I don't know. Again, reasonable minds can differ, but depending on how you approach the bargaining, where you are trying to benchmark, that will greatly influence how you feel about where you ultimately end up. And so trying to navigate that process can certainly kind of inform and influence how people feel at the end of the day once bargaining has concluded. And to the earlier point made about it being a thankless job, it is sometimes important to remember that the bargaining representatives, the union stewards are, you know, just normal men and women who are oftentimes, you know, depending on the size of the unit, you might have somebody on full release time whose primary job duty is navigating the relationship between the union and the employer, but for the most part, they are normal people volunteering their time, trying to navigate these very difficult issues. And so, yes, navigating hurt feelings, being underappreciated, you know, your friend or you heard about this jurisdiction that got a 20% lift, that can all get baked in and leave people feeling a certain kind of way at the end of negotiations.
Right. So then the next one on here is bad faith or surface bargaining. So these, obviously this might be an accusation from the other side that the city or the county or the employer is not doing what they're supposed to do. They're not listening to our proposals. They're not responding to our proposals. And that's really going to be a lot of what we talk about today is kind of this idea of bad faith and surface bargaining. So next slide. So there's a couple different laws that might apply to your bargaining process and what constitutes good faith or bad faith bargaining. These all set a very low bar, right? Hopefully most of you are able to negotiate contracts pretty easily without having a lot of unfair practice charges filed. But again, that bar is really low to meet. We'll go through what that bar is on some of these different issues, but it's obviously the hope is just not to clear that bar, just to barely be bargaining in good faith as opposed to bad faith. But the idea is to keep up good labor relations, right? Presumably these are people you're going to have to see fairly frequently, you're going to work with, it's good to have a good relationship, and ultimately it helps get a contract if you can demonstrate to the other side that you are not just meeting these minimum thresholds, but that you're kind of going above and beyond those. So next slide. Okay, so we've got our usual suspects here, and these are our usual suspects of bad bargaining, or bad faith bargaining. A motley crew, certainly. So, okay, next slide. So here's the common complaints that we hear from the union perspective, and these are really going to be what we focus on today. Delays, lack of response to proposals, lack of justification for any proposals, lack of authority, and just simply not being heard on their proposals. Next slide. So first is being delayed. This one's really easy to control, right? Set deadlines, meet those deadlines, make your bargaining sessions, all those things. So the law does require that the parties confer promptly upon request. Promptly, probably a couple weeks is reasonable. If you need more time, communicate that. PERB, Public Employment Relations Board, has found that evasive tactics of delay, canceling or delaying meetings can constitute evidence of bad faith bargaining. Now, look, it's obviously if somebody's sick or you have a death in the family or family emergency, those are all perfectly fine reasons to cancel. Really what an employment board will look at is the reason behind cancellations. Are you canceling meetings so that you can delay the proceedings, or is there some good faith reason to do so?
Can I ask a question about that?
Yeah, of course.
Does that apply to the union side as well?
Yes.
Right.
Okay.
Unions
Yeah.
can bargain in bad faith.
Yep, absolutely.
Sometimes they do.
I'm stuck in the employer side, so.
So just wanted to add on
Yeah.
that at least a little bit as an overarching theme, and you could apply it to basically everything that we're saying today. I think one of the, central concerns and central mindsets that you really got to be aware of is the union feeling as though it's not being taken seriously. And so not respecting their time is one way not to take them seriously. Not respecting when they take possibly unpaid time in some way, shape, or form to show up and actually do things, take phone calls, various other sort of things. They take it very seriously because this is their finances. And if you're giving off the impression of we're just going through the motions so we can eventually shove this contract down your throat, that's not taking them seriously. And that's gonna, engender hard feelings and frankly make bargaining more difficult. One of the other things, again, that I try to forecast for everybody or, project for everybody at the beginning of this is it really should be an open mind even from the employer's perspective, because part of this is you're allowed to ask questions of the union as well. You can make information requests to them, you can make document requests to them. They put out a proposal. Let's say they want to do something with some of the finances and whatnot. You can get their backup for that. They're required to give you that. They may know something you don't know. They may bring some fresh perspective to it that you want to share with your principals because it's a good idea. And so going in with an open mind, I think, is number one, the overall theme of kind of this set of laws, but is also something, again, going with that overall theme of letting them know that they're being taken seriously. They're at least being listened to. Their points are being considered. Their information is being considered. Again, they may have a good idea. Maybe it saves the department money somehow. And so, they're the ones that are living it. They're the ones that actually know oftentimes how things are happening on the ground. So that perspective is valuable and it should be taken into account over the course of the bargaining process.
Yeah, so.
Can I add something real quick?
Absolutely.
Just to be clear too, just because somebody demands to meet and confer, if somebody says jump, you don't have to immediately respond with how high. There's also case law, for example, that it wasn't a bad faith practice for when an employer deferred making a wage-based proposal until after they had had an opportunity to review the budget, which makes good sense. So I think, and you'll hear this throughout the presentation, a common theme is going to be communicating your position, supporting your position. There's case law that says if an argument is important enough to make at the bargaining table, then it warrants supporting that argument with accurate documentation, essentially. But that makes good sense. I think everybody would agree that reviewing the budget is something that you want to do before you start exchanging proposals about wage increases that you're going to live with, not just for the duration of this contract, but of course into the future as well. So communicating, explaining your position, we'll talk about this more later, but there can be good reasons to defer making proposals or at least waiting some period of time.
Right, so some of the common practices that we see are canceling bargaining sessions, not being prepared with proposals or just prepared to discuss items at those bargaining sessions, and not coming with responses to proposals. And so these are all pretty easy fixes. So our suggestion is, one, be realistic about your timetables. If it's going to take some time to get your proposals prepared, get the authority that you need, get the input from the individuals that you need, allow yourself that time and communicate that to the other side. Hey, we don't expect we're going to have this information until the end of the month. Let's schedule a session for the beginning part of the following month. Be realistic about those things. If there are reasons why you cannot make proposals yet, communicate those and set a deadline. When do you think you're going to be able to actually respond to those? We've all probably been in those bargaining sessions where nothing happens and everybody walks out looking at each other going, what did we just do? We showed up, we signed our little sign-in sheet, we said hello, maybe we talked about a few little things, maybe we scheduled another session, but nobody moved the ball forward at all. Okay, if you're in that position where you know you're not going to be able to move that ball forward, you're not going to get any closer to a deal, probably alert the other side. Hey, just as a heads up, here's what happened. We're not going to be able to come with proposals tomorrow. Do you still want to meet? They want to meet? Fantastic. We're not going to cancel just because of that. If you all have information you want to present, fine. But at least you're putting it on the other side. It's going to be very hard for the union after that to say, oh, well, they canceled our bargaining session. Well, they didn't cancel it. We asked you if you wanted to hold the session. We told you that we did not have, some requirement, but we were still willing to meet. We told you when we thought we could meet. So again, Ian mentioned, and I think we probably all mentioned at this point, a lot of it's just communication, making that communication as early as possible so the other side knows what to expect.
And just as a practical matter, I don't know, you guys can speak to this too. I never participated in bargaining that went on schedule. So always build in cushion and do the hard work, or to the extent that you can, front load it. Because life happens. Worked with some jurisdictions in the North Bay, fires happen, natural disasters, just things happen. And inevitably it delays bargaining, so.
And one other kind of remedy for that is well-drafted ground rules. Putting out expectations ahead of time. This is what's going to happen if we can't make a meeting. This is what we're going to try to do with regards to our proposals. We'd like to have financial proposals, understanding that those are the meat and potatoes, out by this particular bargaining session, so we can start the real discussions on it. And again, you could put in things with regards to communications into ground rules. I do this all the time, which is, communications with regards to scheduling, offers, various other things shall be in writing. Send a text, send an email, have your nice record. Later on, it will protect you. But these kind of things as far as managing expectations, again, go into my kind of bucket of taking them seriously and them taking you seriously. It should be a good business relationship.
Okay. Next slide. Okay, so we just covered this, so let's go one more slide. So next, obviously critical component of bargaining is making and hearing proposals, right? I mean, this is what probably most of your time in a bargaining session is going to spend doing. So the law, again, really low bar here. One, a flat refusal to reconcile differences by failing to offer counter proposals could be construed to be in bad faith. So even not necessarily bad faith. You can still have a flat refusal and an inability to reconcile differences and it not necessarily be considered bad faith. And then secondly, to meet its obligation to bargain in good faith, party must be willing to exchange reasonable proposals and try to reconcile differences. Okay. Lastly, and I think this is a really important one, the parties must explain the reasons for a particular bargaining position with sufficient detail to permit the negotiating process to proceed on the basis of mutual understanding. So I think, again, we've all talked about that is don't just make a proposal, back it up with some justification. And if you have documentation to support that justification, even better, okay? All of this stuff that we'll see in terms of what constitutes bad faith bargaining, you're allowed to bargain hard. You are not obligated to take the union's position on anything, but you have to have a reason for your proposals, okay? It's not enough to say we're going to give you 0% wage increases and we need a 3-year contract. That might be bad faith bargaining if you don't explain it. If you explain that you're in a deficit, the economy, we had a decrease in our taxes, whatever the case may be, if you have some justification for that, you are absolutely entitled to offer whatever you deem appropriate for your organization.
And
Well, I was just gonna add in a little flavor with case law. I mean, there's a specific case, this particular county had a pot of money, but they were concerned about ongoing expenses, and so they didn't want to convert this into, wage increases or whatever. And so they were willing to spend the money, but only in the form of one-time money. And the union consistently objected and refused to acknowledge the legitimacy of that position, but the county did support their position with, financial information. They went over the financial information with the union. They explained their position, the justification, therefore, and PERB found that that was not bad faith bargaining, because again, hard bargaining, and I think we have a little more on hard bargaining in a couple slides, but it doesn't require you to make any concessions to the union or compel you to take, any certain action, but you do have to, as Vance was explaining, support your position with information, with the justification. You could even be wrong, I suppose, but you just have to have a framework for why you want to do, or why you're proposing or refusing to engage on a particular proposal.
And just to add to that particular point and going along with our overall theme on this stuff, it's really your position is as defensible as it is you're able to explain it. And so that can be some of the documentation you're talking about, but don't forget, if you're actually hoping that they're going to sign this contract at the end of the day, as opposed to going through imposition and various other sort of things, you're still having that conversation that they're gonna understanding, they're gonna have to have that same conversation with their membership as well later on. Help them explain it, help them understand how this is happening, give them the documents so they can make that explanation as well. And then also understanding that it's that explanation, it's that demonstration to the union that is protecting you legally later on. And so it's worth your time, and especially if it's a financial thing, something else of that nature, this is stuff that's ripe for being able to demonstrate with a documentary record of some sort or another. We all understand what being in deficit is. We all understand when a hard economy is out there. These are the kind of things that have to actually be said at the table, and even better explained in writing at the table. And then maybe you're making concessions somewhere else, understanding, guys, I know this is hard to swallow right here, so we're going to try to take care of you over here a little bit. But that kind of demonstration, again, is what's going to protect you later on, but is also what's required by law.
Yeah, and I would add to that, I think what Kevin said is a great point, in that really what you're doing in part is you are giving that union bargaining team some ammunition for when they go in front of their constituents, when they go in front of their membership, to say, hey, here's why we're getting this raise, which is less than you all think. You have to take these things into account, right? Because ultimately, those are the people that are going to be approving that contract or not. So your goal is to push that bargaining team to come to a tentative agreement, but also giving them that information that they can go on to their membership. And I'm gonna actually kind of go backwards, say, when you get some guidance from whoever your decision makers are, ask them the justification. Sometimes, if you're not getting the authority that you need to negotiate that contract, forcing those decision makers to articulate a justification is helpful. They might realize as they're halfway through their justification that maybe their justification isn't so great. And then you can look back at them and say, I've got to tell the union something. By the way, the law requires that I tell the union something for our justification. You've got to give me something. Maybe they give you a little bit more authority. Maybe they find some justification, right? Because again, you're trying to be that conduit between the ultimate decision makers on your side and the ultimate decision makers on the other side. And both groups are kind of in that middle ground. So really, I think that's a great way to do it, is ask those questions, ask follow-up questions. So go ahead, next slide. We covered a lot of this, but again, the common practices are the proposals with minimum justifications or unclear motives. So maybe you have a specific motive for why something changed. Maybe it's something as easy as, well, hey, there's a new state law. If there's a new state law that requires you to make a language change, that should be an easy one, okay? But you've got to explain that, provide that perspective. Best practices we've really covered. Have a reason for each of the proposals. One thing I would add on to that, give yourself like a one-line explanation, right? When I kind of put together my negotiating materials, I have proposal 1, wages, and then I'll have 2 bullet points under it. Total comp survey, decline in tax revenue by 15%, right? It's something, so I can go right here in one little sentence, I can articulate the justification. It makes it easier for the other side to then, hear that, interpret it, and then take it back to their membership when they need to.
One additional thing just with regards to justification that I wanted to throw in there that is useful. At the beginning of the bargaining process, I think something that is not just a good practice, but an essential practice, is asking the open-ended question to the union representation of where their priorities are. Because oftentimes what you'll end up with authority is something of a pot of money. It's not so much where that money is being spent with regards to the various sort of things that they could be spent on with the employees, but rather the total bottom line figure that fits within budget. And oftentimes you'll be surprised by union priorities. And sometimes having that information ahead of time can make you stretch a dollar a little bit farther. And certainly when you're giving justifications for why you're putting more weight towards various assorted items, if you're literally putting together a proposal that tracks with the priorities that they previously gave you, that's a heck of a justification. Again, that's just more communication right there. But it's surprising how, giving weight to their priorities, and ideally what they've done ahead of time is literally had a meeting with the membership and said, hey, what are your guys' priorities? Can you give us a temperature on that? Seeing that reflected back in the contract that's eventually produced for ratification is another thing that's going to help it get across the finish line with regards to that membership vote. So these are all, again, things just to kind of make sure you involve them in the bargaining process to hopefully get it across the finish line.
And again, just one final point. Unions also have, as I'm sure everybody knows, the ability to request information, and the failure to provide information is a violation of your duty to bargain in good faith. So notwithstanding the fact that it's a best practice in the context of bargaining, you can also reasonably anticipate requests for information if you are saying certain documents or certain policies, laws have, provide the basis for your proposal. Especially depending on the law firm you may or may not be dealing with, you can rest assured you're going to get requests for information for the basis for the proposals.
Right. Okay, next slide. So still kind of on that same subject of making inherent proposals. So another thing that we've seen is ignoring or not responding to proposals or positions and kind of more focusing on the proposals that you've already made. So you have your set of priorities and what you're trying to get accomplished. The union has their set. It's really easy to just focus on yours. Okay, Kevin already mentioned it too. Get their priorities early and try to do something to accommodate something on that priority list, right? Even if it's a small win. Again, you're giving them something that they can then take back to their other side. And again, asking those questions, why? Every proposal that comes across, what are you looking for in this? What are you looking to accomplish with this proposal? And it might just be, well, we'd like a little bit more money. Okay, probably the justification for a lot of proposals, but there might be something else. And again, going back to posing that question to them and forcing them to explain it might kind of make them realize that maybe their proposal is a little bit silly. Okay, at least having to articulate that. I'm sure all of us, if we've made a proposal, and perhaps all of you, if you've made a proposal that oh, this is gonna go over like a lead balloon, right? This is not going to go well, and you get pushed on it and asked a couple follow-up questions, there's no worse feeling. Like, oh gosh, okay, how am I gonna justify this without just sounding like I've got a bunch of marbles in my mouth and spitting out nonsense, okay? So, put that pressure on the other side a little bit too, and it's completely fair. Why are you all looking for this? Maybe they have a good reason, maybe they don't. If they don't, maybe move that down in terms of what they think is their priority. Last part too, going back, when you then speak to your decision makers, you now have something from the union. Hey, the union wants to make this small little tweak, and here's the reason why. What do you guys think, right? Put that question to them. And if they don't want that, have them give you justification. Okay? Yeah, go
I just
ahead.
thought it was funny that, in my experience, proposals that came across from the union side, it was amazing how often they began with, let's just see what they say. Or see what their justification for not doing this is. And, setting aside that kind of extreme example with it, even when they're coming forward with a serious proposal, if you're gonna say no, at some point in time, they're gonna be going back to their membership and explaining to that membership, why did you say no? And so you truly are giving them, like, I've seen it happen before. You go back to that union meeting afterwards for the ratification and you're hearing management talking points being said by the union representatives themselves. They're taking what they took as legitimate expectations from you and bringing them back to the membership, functioning as a good conduit. And again, as long as you're putting out those legitimate justifications, that legitimate reason for saying no, the reason that, we're putting priorities elsewhere would be another really good way of describing it. It's gonna, again, help them do their job when they're on the firing squad end of it.
Yeah, absolutely. Okay, next slide. So again, we covered these, ask questions, assess their priorities, ask for their reasoning and documentation, like Ian said. You can ask just in the bargaining session, hey, you mentioned that you all think you're 10% behind the market. Can you show me whatever you did on that? well, you know, we did kind of a salary survey. Okay, well, if they're not willing to give that to you, you can ask for it in a formal request for information. It might be something that attorney-client privilege or something, but you're entitled to information if they're pushing on things. So if they've done kind of an internal survey from the bargaining team, even if it's rough, ask to see it, see what they're looking at, and find the holes. What's wrong with it, right? So another really easy way to kind of keep that process going, making it clear that you're listening to the information that they're putting across, you're absorbing it, that you're processing it, and then you're coming back with some form of a response.
I think it's also a really good tell on which proposals they're taking more to heart and they really care about. The ones they care about, the ones they really believe in, they'll actually probably have documentation for. They're actually done their homework on those particular ones. And some of the sillier ones, I have done things where I've asked for backup documentation on that and then that proposal is withdrawn.
Right, yeah. Makes it a lot easier.
Yeah. So it's a good way to kind of test things out and expect to be tested yourself too with regards to your particular proposals.
So I'll add to that, because one thing that at least I did when I was on the union side negotiating, I would get the list of priorities that Kevin talked about, and I would write up proposals. And sometimes it would be a lot. It would be 6, 7, 8 proposals on these different things. That would a lot of the time be interpreted, I see laughing right now, that would be interpreted as, oh, you guys want everything. Well, not really. One, normally your ground rules say that you have to put proposals across by a certain meeting. So if I don't bring up this particular issue now, I'm going to waive my right to do it. 2, we're trying to see where we can get some traction here. What are you open to and what are you completely closed off to? Okay. And if your response to all 5, 6, 7 of those proposals is no, well, then we're going to keep pushing on all of them. But if you can give us a small win on one of them, all the rest of those might go away. Okay, you're giving them something to take back to their membership. Hey, we were hoping for a little bit more on wages, but we got an increase to our 401k contribution match. Oh, okay, that's a nice little increase, right? Those little things like that can really go a long way. So really try to find, you know, Kevin said, I think, bang for your buck. Where can I get a little bit more bang for your buck? Well, if they're pushing proposals across on some economic things, but they're not wages, and maybe there's not something that's not going to be pensionable, consider those things and see if you can come up with a little bit more money to give them a win on one of the proposals. Because then they know that you're listening to all those proposals, that you're trying, okay, but you're only able to get a win on one. Fine. Most groups can live with that, right?
Sometimes some of this stuff falls under the category of just being heard as well. Larger unions in particular, where there's just a really big diversity of views across the membership, you know, and a large bargaining team, like 8 or 9 people or something of that nature. Sometimes just working with them, and from that perspective, the piece that was made as amongst the bargaining team was, we're gonna let the more extreme faction say what they want to say in the way that they want to say it, and make the proposals in the way that they want to make them so that they can be heard. And you can go back to the membership and say later, we did that, we put that out. Those words were said, we stuck up for you. And the other thing too that is always important to remember is, especially if it's you know, the first time you've been doing bargaining with a particular unit, there may be a history there that you don't know about. There may have been a very, very sour contract the last time. There may have been unfair practices and bad faith bargaining. Maybe somebody did something about it, maybe they didn't. You know, I once had a unit that had been out of contract for 8 years, which is insane. And they were mad as hell and not gonna take it anymore after all of that. But just walking into some of those things and understanding that there's history on it, sometimes that history needs to be heard. Sometimes that steam needs to be released, so to speak. And the bargaining table is a really good place for that. The other place, unfortunately, is the ratification meeting. But trying to be respectful of that history, giving them a chance to be heard, and not just dismissing things as opposed to, we hear you and this is where we're coming from and this is why, I think is truly part of your job at the bargaining table. And respecting that history, you know, and sometimes it's nice to say, you know, we're doing things different this time around. Sometimes, we were joking about this earlier, you have different economic situations and different law firms hired for different economic situations. You get your bulldog, you get your peacemaker, based in different circumstances that might be confronted by the public agency. And so again, there may have been a very, very sour taste from the last time around, and you might have to kind of bring forward the healing process at least a little bit to address some of those past issues. But again, just things to, again, take into account when you're sitting across the table and understanding who those people are and where they're coming from.
Let's go ahead and go to the next slide. Okay, so this is, again, something that can be seen as bad faith bargaining. This is a lack of authority or just simply hard bargaining, right? There's kind of a difference there. So first off, on the lack of authority, a negotiator can discuss issues and make proposals that are subject to ratification unless a limited authority is intended or was used to foreclose achievement of an agreement. So obviously, ultimately, your contract has to be ratified by your decision makers. It has to be normally by a board. And that's fine. You do have to have the authority to negotiate, okay? And so you have to go to the table with that. They don't have to give you full authority to do whatever you want. You can have a limited authority, provided that the limited authority isn't to try and undermine the process in some way. And then next, always helpful, that hard bargaining is okay. Again, you can take a hard position and you can stick to that position. That is completely justified, it's completely permissible. As long as, again, the proposal was supported by rational arguments that were communicated to the union during bargaining, okay? Again, right there, it's gotta be part of that communication. You can take a hard position, you have to explain your hard position. The other side's probably not going to be satisfied with it, but you're doing everything you can. You're certainly meeting the legal requirements, and you're probably even going a little bit above and beyond. So next slide. So some of the common practices that we see are not giving sufficient authority to negotiate, right? I mean, one of the most frustrating things to hear is, well, the board only approved this. This is all the authority that we have. This is the only authority. Because, okay, well, who am I negotiating with, right? If you don't have any authority, and you're just the messenger between the board and us, why aren't we just sitting in front of the board, okay? And then that dovetails on blaming the lack of authority for not being able to negotiate. Well, we don't have authority to negotiate on that proposal. Okay. Can you get the authority? Did you ask for the authority? When can you get the authority, right? These are all justifications that, at least in my experience, can fall on completely deaf ears on the other side. Because from the union perspective, it is their goal and their job to ensure that ultimately their membership approves a contract. It should be your goal and your job to get enough authority so that you can negotiate a reasonable contract. So really try not to just be that middleman, that messenger. So better practices, get enough authority so that you have some room to negotiate, okay? Ask for more. Hey, they also passed across this proposal. We'd like to be able to discuss a 401k contribution with them. Can we have some additional authority for that? Whatever that may be, give yourself some room to be able to go back and forth. And again, leave some room for some compromise on positions. And have document-based reasonings to support the positions that you have if you're taking a hard position in one way, shape, or form.
I think, yeah, that's key, because again, it's not that you have to respond to every proposal. In fact, you don't have to respond to every proposal, but you do need to provide a clear and cogent explanation for why this particular issue is not going to be receiving a counter proposal, right? You will hit the limit of your authority. I guarantee if you bargain with the union long enough and keep making counter proposals, they will keep pushing and pushing and pushing. At some point, you do hit the outer limit of your authority. Maybe you want to hold a little bit back for fact finding and make a move at the end, right at your the time to issue your last, best, and final. So there are circumstances under which you may want to keep some of your powder dry, but I think, again, coming back to the common theme, you need to have an articulate basis for why you have now reached the end of the road on this particular issue, or you're not entertaining any further discussion on whatever the proposal may be. And in fact, at that point, I would almost argue if they continue to make proposals and you've explained that you're not entertaining this particular subject, now at this point, arguably, they're making predictably unacceptable proposals, which is another indicia of bad faith. So it really, as we've said many times now, comes back quite often to being able to articulate the justification for your proposal.
And lack of authority on its own is not justification, right? That might really be where you are in the process, but you have to have something. Well, our priority is to put as much to wages as possible as opposed to diverting some of the money to these other things. That's a justifiable position. Really what you're saying there is we don't have any more authority because you've reached the max of your authority in terms of money that can be spent. But you're putting it in a little bit of a different lens. It's probably going to be a lot more palatable to the other side, okay? And their response might be, well, take a percentage off of the wages and let's talk putting that somewhere else, right? If you're really at that kind of impasse point, then you'll really see where some priorities lay, right? If you make them really decide where that money goes, you'll get a really good view of where their priorities are pretty quickly.
So speaking to the subject of hard bargaining on some of these things and kind of the step-by-step and compromise process on some of these things, just from the union perspective, it's important to understand that they do expect you on many subjects to probably move at least a little bit. So while you might have a specific reason with regards to why you think you should have a 2-year or a 3-year contract, the degree of raises, the percentage of raises, not only are they not expecting the offer that they're going to take from you the first time around, but maybe they're expecting 3 or 4 iterations afterwards as well. And, you know, I'm going to do a high ball, you're going to do a low ball. This is what's going to happen to begin with. Then after that, we're going to start moving towards the middle. And at some point in time, we're going to hit what we both think is kind of reasonable. You know, putting that out there for your decision makers so they can kind of understand the process, and then understanding that, you know, this is something that you're going to do over a series of meetings. You know, we're both going to smile at each other when we send out our opening proposals because they look silly. But nonetheless, that history, that setting forth all those different steps to get to the eventual reasonable right there is going to be more protection for your position later on that you have actually bargained in good faith. The moving from the position is definitely indicia of that as well. And of course, if you're not going to do it, if you're going to take those hard positions, those are ones that should be picked with care and certainly justified, ideally with document-based reasons, as opposed to some other things, in particular finances. You want to be very careful about that. But anyways.
Yeah. Anything to add on that one, Ian?
No.
Okay, so let's go to the next slide. A couple more things that really follow up on that topic. So first, a real pet peeve is this idea of internal equity, right? Well, if we gave this 5% raise to you, we would have to give every other group a 5% raise. Well, that's not true, right? That's not true. You don't have to give every group a raise. In fact, PERB has specifically said that an employer comes perilously close to bad faith when it insists that it will not under any circumstances agree to different terms for different employee groups. And that's kind of what you're saying when you're saying, well, if we gave you this, we would have to give them this. Uh-oh. So
it resonates with us.
Yeah, right. And now, keep in mind, it does go both ways, because certainly if another bargaining unit just got a really good contract, well, then now this other bargaining unit that you're going to negotiate with. So, but I think for that, you have to just make it clear at the outset. Hey, we are bargaining a contract for this group. This group has a specific set of circumstances that we are going to try and tackle and that we are going to try and address. You all have different concerns than the other groups have, and we're going to try and take care of those things, okay? Those type of arguments never take into account market data, which, as Ian said, it's the North Star. Where are they in the market? Okay, if this one group is way behind in the market for whatever reason, they are probably going to get a bigger bump than everybody else. That's completely reasonable. And, you know, at least from my perspective, all of those kind of internal equity arguments should be shut down pretty quickly, kind of, you know, just shut it down, move on to a different subject where you've got another argument.
It's very difficult too, because, you know, like I mentioned during my initial introduction, these labor contracts are not being bargained in a vacuum. They're the product of trade-offs that have been made, in some cases going back decades. You know, one unit prioritized a certain benefit, another unit prioritized wage increases. And as a result, it's not uncommon for labor contracts to look very different in the here and the now, but it's a function of the priorities and the concessions and the trade-offs that were made by the representatives going back many years. And so it does get very tricky or tenuous, I should say, to hinge your argument, a Me Too clause, everybody's familiar with that, just on the Me Too. Well, he or she got that, well, Me Too, I want it as well, without acknowledging the not past practice, but the past relationship that ultimately brought everybody to this situation to begin with.
Yeah.
And I mean, something else that's kind of interesting, and remembering the overall theme of justifying your position, right? Different contracts happen at different times over the course of a year, over the course of several years. You might be having a great year financially when this first contract got negotiated, and then everything went into the tank afterwards. There was a big event, there was a big liability, suddenly the coffers are empty. And so these are the kind of justifications that you're supposed to come forward with when somebody says, well, that's not fair, this person got this. Well, it's not about that. It's about what we actually have to be able to give you right now. It's about the history of the particular unit. It's about various other sort of things that aren't just everybody gets X amount of percentage each year. It has to actually be, and I think case law backs this up as well, the individual circumstances that this particular unit is subject to. And that's the kind of stuff you're supposed to be passing back across the table that will protect you later on.
Yeah. So Ian mentioned Me Too clauses, and I'll just give my 2 cents on Me Too clauses. Don't do them. And if you do them, you have to be really, really careful. A lot of litigation arises out of Me Too clauses. Okay. And then on top of that, you have the issues, Ian's laughing, because right, everybody can think of a couple of real knockdown, drag-out fights over interpretations of Me Too clauses.
I went all the way to the Court of Appeal
Right,
on a Me Too clause.
Yeah.
It was just, yeah.
But it also puts, right, you're kind of just kicking the can down the road, and you're putting yourself in a bad position for that next contract where the first contract, the Me Too clause is written about, right? Now you're dealing with this other unit, but you're also might be causing yourself a problem with this other unit because they have a Me Too clause. And when this unit asks for a proposal that triggers the Me Too clause, now you're looking at the cost of both of those going up together, right? Especially when you're doing it within your group. It's one thing, I mean, I've seen some of these where if this other comparable agency gets a wage increase, then you might get bumped up. I think that's a little bit more reasonable. I think there's a good argument that a lot of these Me Too clauses can be seen as bad faith bargaining in the group that is kind of covered by that Me Too clause. It might trigger that Me Too clause because of those additional considerations. That's that. And then also you have to be, if you do them, you have to write them super carefully or you will end up in the Court of Appeals. Because what exactly triggers it? What specifically are you looking at which might cause that trigger? A lot of interpretation and some wiggle room in some of those, and it can cause a lot of problems. Okay, next slide. So this one is just
More pet peeves.
Yeah, more pet peeves, more gripes that I kind of see. And so, on here again, inability to pay. I think we kind of touched on it earlier. Inability to pay is probably the thing that gets most used and is least understood, okay? There's a difference between an inability to pay and a desire not to pay, okay? City of Stockton went bankrupt a few years ago. They had an inability to pay, okay? Most of the time, if you go in front of the fact finder who's actually going to look at an inability to pay, it is almost a non-issue. It takes a lot to be able to show that there's really not an ability to pay. I am licensed in Nevada. I was bargaining some contracts in Nevada, and the county threw out, we can't pay, we can't pay, we can't pay, we can't pay. We went all the way to a fact finding. By the time we got to the fact finding, the county just completely acknowledged we have an ability to pay. Because the attorney finally turned to them and said, I'm not making this argument in front of a fact finder because we absolutely can pay. So really find a better reason, okay? Whatever that might be, but throwing around that inability to pay should be those real dire circumstances where your budget is falling apart and you're at least at that point of, are we going to be able to meet payroll over the next couple of years?
And it's funny too, because it's not a necessary reason. You can assert policy-based reasons for not giving raises, which are perfectly supportable and are going to be defensible later on if you're challenged in a legal sense. It's just harder to make that argument, and I almost feel as though people often take the position of inability to pay because it's the easiest one to say, we don't have the money, as opposed to, we think it needs to be put into these other legitimate priorities as well. I think I have up there, fix the roads, other assorted things, public works, these are expensive, big ticket items, maybe make a new park, something of that nature. Those are all legitimate things to be out there, and the public agency isn't necessarily going to get second guessed on policy decisions as to where they're putting their money by PERB or anybody else. And so, you don't need to just run to inability to pay so much as just, no, this is why we're not putting a priority on your wages. And sometimes that's a politically difficult thing to say, but just as Vance was saying right there, if you get called to the carpet on inability to pay, you might just end up being politically embarrassed later on. And so there's a lot to be said for, pick your battle, pick your legitimate reasons behind this, and then come forward with those reasons as well. Understanding, yeah, you should be able to sell them to the unit because otherwise they're not going to be able to sell it to their membership. But I think my favorite thing actually out of this entire part is the very, very bottom one right there. What do we get out of this? That could be the overarching theme of the entire union position. And they want to know that because they have to explain that to their membership of this is what you're getting out of this. And so, it could be an increase in pay. What kind of percentages are we getting for the next couple of years? But it could be, fixing other things that just don't work right with the contract and have been a headache to the unit. And so again, being able to explain to them, this is why this is a good contract for you. And it just amazed me that more employer sides didn't take the time to do this during bargaining. When again, they're only helping themselves by putting across those points and saying, this is what you're getting out of it. And again, taking it a little bit further and sitting in on those ratification meetings, these are the things that are said, help them. Help them get it across the finish line.
And on that point, I'm sure as you all are bargaining, you're doing some form of costing and figuring out what proposals cost. I think it's really beneficial to show to the other side that costing. Okay, you might see this as a 2%, piddly raise. Well, really what that equates to is $1 million over the term of the contract, or whatever that number is. And I like to, when you can break it down by employee. Look, you have this employee, brand new employee starting today, they're at this wage. Next year, they're going to get a step increase and they're getting an additional 2% cost of living adjustment. And we're doing this other stuff to increase the wage in this way. And then at the next year, they're going to get this. That one employee from day one to the end of this contract is going to see a X% raise. And when you put it in real dollars like that, it has a bit of a different effect, okay? And it shows a personal effect to some of these people. This is their take-home pay that you're discussing. So you're really showing them exactly, okay, I get it. 2% every year doesn't seem like a lot when you combine it with some of these other things. It's actually not bad. Or if it's more than that, hey, this is pretty good. And it can be a really effective way to get, again, that buy-off from the membership.
And to that point as well, some of the other things that may seem like very low-cost items, like medical benefits, retirement benefits, other things, they don't seem like they're big numbers, but then when you actually confront the costing of it, and especially, do it by a particular employee, also do it by, if we do this tiny little bit, seems like this tiny little bit for the entire unit, here's what happens, and here's what happens over time. And I do actually think there's a bit of ignorance on the other side for those particular points sometimes, and it's worth your time to actually explain that, especially if you're saying no. Anyways, and again, the biggest takeaway from all of this is, for my part, the explanation. And it was amazing how often that never happened, looking at it from the union side. There was always a no, but there wasn't a but why. And I think in here we had some graphic of, because I said so. That's what it felt like. Taking away that just mystery of why is this such a problem? Why is there such a firm no to this? I think is truly the job of the employer side bargaining team. And if you do the effort at the front end here, then you're not paying for it at the back end at PERB.
One just observation that I'll make too, having gone through the ratification votes on the union side. That bargaining team is always way more pessimistic than they need to be, right? Every time, oh my gosh, this is gonna get voted down, they're gonna laugh us out. I don't know if a single employee is going to vote in favor of this thing. Oh, it got approved by 85%. Right, I mean, that is consistent, I mean, and that goes back to some of this other stuff we talked about, the pressure on the pressure on them and kind of those high expectations and all that kind of stuff. So it's about, that bargaining team can kind of get itself ramped up and all the stuff that we might be able to get. Generally speaking, the membership is gonna sign a contract that gets in front of them. Okay, it's pretty tough for them to turn down some of that money. One pet peeve I wanted to add on here, which kind of fits with a lot of this. You really need to have a unified voice coming from your group, and that's your bargaining team, but everybody around. I mean, I've had the situation where we had the board of supervisors of this county were going around to our individual members before bargaining started. It wasn't unfair practice, anything like that. Telling them, don't worry, we're gonna take care of you guys. We're gonna take care of you guys. We've got you covered. Don't worry about it. We know you guys are below. We're gonna take care of you, okay? So everybody's expectations going into bargaining were sky high, right? I mean, do you think 30% or 40% over the span of a couple of years? I don't know. Well, guess what? The proposals came across and they were higher than average proposals. Oh, this is terrible. The bargaining team is trying to screw us. They said they're gonna blah, 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 right? Those little communications carry a ton of weight and really stick with people. So I get it, these are kind of the people that you respond to and that you have to answer to. You've got to do your best to try and keep them in line, but shoot, if that's going on, go back to them. Hey, you guys said this and now we're not able to get a contract because everybody's thinking that they're going, they're already looking at new houses. And meanwhile, you're only giving them small little bumps. And at least on the union side, I had to temper those expectations a lot. My question was always, oh, wow, they said they were gonna take care of you. How much of a percent did they offer? Well, we didn't talk about percentages. Okay, I bet you if you went back and asked them, hey, I thought you said you're gonna take care of us. Yeah, we offered you 12% in 2 years. That's taking care of you, right? So it's real easy, especially when you get the politicians involved, right? The politicians are gonna be out there, oh, we're gonna take care of you. This is great. Oh, we support, this group. We love our law enforcement. We love our firefighters. All this kind of stuff. Do what you can. Keep a unified voice, because otherwise it's going to make for a really, really difficult bargaining process. Ian, closing thoughts on anything? I think this is our last slide, and then we'll do some questions. But
no, just probably piggybacking off of the theme I think that's run throughout many of these slides. When I got involved in collective bargaining, oftentimes I came in at the end when it was headed towards litigation, perhaps an interest arbitration or an unfair practice charge. And it's quite surprising how often we would get involved and it was clear that they were just talking apples and oranges at the table and that there was a communication breakdown, whether there was a total compensation survey that was not being applied correctly or people had different data points or even using different data points. I mean, reasonable minds can differ about what comparable public agencies are, but nobody should disagree about, what the longevity premium in Salinas is or, what the post premium in Roseville is. And so collaboration early on and the communication that we've talked about can help at least set the stage where you can have a disagreement potentially, but at least you're going apples to apples and you have a chance to resolve your differences. But when people are not on the same page, there's almost no hope.
closing thoughts, Kevin, before we go to questions?
Difference from going over to union to management for me is oftentimes there's a little bit of removal on the employer side. And I mean that specifically in that these employees are in there and they're bargaining over their contract and this is their pay, this is their livelihood. It's not somebody else's money, this is their money. Whereas on the employer side, you're dealing with somebody else's budget. It truly is, public money, and there's responsibility associated with that, but there's a degree of not as personalness. And so, when somebody's sitting there and inflation is hitting them in the pocketbook and they're a public employee and they're not paid that much to begin with, some are paid more than others. But nonetheless, it makes a lot of these issues more personal, and it makes it a lot more important for them to be heard on some of these personal issues as well. And so I think there's a little bit of a disconnect with regards to the emotional connection that a lot of these people feel. And that when they're putting across these proposals, this is their life. This is what they think they're going to be able to buy a new house with. This is what they think they're going to be able to buy a new boat with, or, pay for kids' college, or any number of things along those lines. And so understanding that, is where they're coming from on the union side of this stuff, I think kind of gives a lot more color to why they take it so seriously, want to be heard, and want to hear why they're not getting that money that goes directly towards their livelihood and ability to put food on the table more so than often they get, as opposed to just this is what you're getting and you better smile. And so again, if there's nothing else to take away from that, it would just be take them seriously, put across those explanations. It helps them, it helps you, and it makes for a better employee relationship.
Any questions, any comments from the room? And it looks like there's a couple on Zoom, but we'll start with anything in the room. Seeing nothing? Oh, yeah, go ahead.
You mentioned contentious bargaining. And I was actually on the union side of the table with contentious bargaining on a very, and if I mentioned it, you would all know exactly probably what it was. But one thing I noticed now being on the management side of the table is you will get very, very personal attacks from the union side of the table. Don't take it personally. A lot of times they are just, I call it the dog and pony show for their members. But I was on the other side on the union side, and there were very degrading comments made at the negotiating table from management, which actually fueled a lot of the union members' angst in the negotiations. So I would just comment that keep it buttoned up on your side of the table, because you can't control the personalities and the popularity contest that occurs on the other side with who they put there, but you can control how you react to that.
Yeah, absolutely agree with you.
And I mean, to that point as well, sometimes with the union bargaining team, the membership wants to hear that they were sticking up for them at the bargaining table. They want to hear that they were pounding the table and really, giving them what for, so that they can see they were represented. And to a certain extent, I think that really is the steam valve, letting off some of that tension, being heard, and you kind of got to allow that to happen and maybe even welcome it a little bit so that, you can move on past it. This is a problem. This is something we need to talk about. Even if we can't resolve it right now, just be heard on it.
And one thing that I've seen work pretty well, because I think part of the problem in that is, yeah, there's contentious bargaining, but a lot of it is because they haven't been at the bargaining table in 2, 3, or 4 years. So now you're dealing with potentially 4 years of pent up anger, aggression, right? I saw a lot of this when the cost of living was going sky high, right? And all these groups are locked into contracts with 2% cost of living adjustments. Meanwhile, cost of living actually goes up 7.5% in a year, right? So by the time those groups get to the bargaining table, they're ready, they're mad, they're ready, they're all fired up. And it can also be some of the dynamics outside of the bargaining table. Maybe, your department head of this one department is not the nicest boss. And well, the only time that they really get a chance to a real seat at the table is at a bargaining session, right? And so you are gonna get that release of steam. One thing I've seen work pretty well is establishment, and I see it in contracts too, is regular labor and management meetings. Once a month, we're gonna sit down at lunch and we're just gonna kind of talk about stuff that's going on. And at least then you're kind of slowly letting off all the steam throughout the term of a contract, and it might help a little bit by the time that contract comes around. Even if it's, if you're in contract, you're not discussing, you're not bargaining, but it's at least kind of being on top of some of the things that are going on. Maybe you'll be able to identify issues before they turn into a grievance or an unfair labor practice, stuff like that. Heather?
Question on Zoom chat, if you could rephrase when you answer it, so everyone can hear it. If you make an opening wage proposal with a good justification, and then you agree to move up in response to union's position, it seems like it could be hard to justify your new position. Do you have to find a reason each time you ratchet up to explain why you won't go higher?
So the question, just so that everybody on Zoom can hear it, basically, if you're just increasing or changing slightly a prior proposal, do you have to provide a new justification every time? It can be helpful. You don't have to if you're providing an increase to a wage proposal. Probably pretty self-explanatory. I doubt that there's going to be much of a gripe from the other side. Yeah, maybe they would wish it were a bigger proposal. But it can be something pretty quick. Okay, we heard from you that wages is your number one priority, so we were able to put a little bit more money to the wage line. We'll go up an additional %, whatever that number might be.
Yeah, I mean, by no stretch do you have to show up and immediately disclose your bottom line. I mean, that would be absurd, right? And I think it's helpful too to keep the relevant analytical framework in context. Everything we've been talking about is surface bargaining or bad faith bargaining. There's two different kinds. There's a per se violation. So you violated some statute that is automatically a violation of your duty to bargain in good faith. So for example, you choose not to bargain over a mandatory subject at the union's request to meet and confer. They would be immediately off the perb. You have violated your duty to bargain in good faith. Everything we've talked about here today falls under a separate umbrella, which is kind of trying to divine the party's intent at the table, and no one factor is dispositive. So really, you look at the totality of the circumstances at the bargaining table, and what you're trying to evaluate is whether or not the parties legitimately had, or I think the correct word is a genuine desire to reach agreement. And so you can negotiate, you can start at 5% and move to 6% and move different proposals around, but it's the analysis is, are you trying to reach an agreement? And I don't think that you necessarily need to worry about moving from one proposal to the next. The only time you're going to get in trouble is when baking all of these different factors together, somebody can make the straight-faced argument that you're just going through the motions, you don't really have any interest in reaching an agreement, and you're just here spinning your wheels, and really perhaps you're rushing to impasse and you're just going to impose on us your last, best, and final without hearing from us. That would be the concern. So I don't think necessarily against that backdrop, moving from one proposal to another is really cause for concern.
And I mean, too, with some of these things where there's actually like a violation is more of a horror story in the situation that you described. I was in a bargaining where the management attorney was playing guitar in the room while the union provided proposals that he did not listen to. That actually happened, and yes, that was a problem. Don't do that. But what we're talking about as far as number one, hearing the proposal, asking for justifications, providing your reasoning back to it, that gets you pretty far from there. And even the example given there of you had your initial proposal and you provided your justification for it. The union came back and said, well, we don't think this should be a hard proposal, and you're asking if you can move and then provide additional justification. Yeah, it's entirely possible, for instance, that let's say you said, we're gonna get this park built. And that's why we can't give you this raise. And it costs this amount of money and those two things can't exist. Well, we're gonna make a smaller park now. So you have a little bit more money. And there was popular support behind that. You went through all those various sort of things and you say, okay, we can get a little bit more money into your wages now at this point in time. Again, to Ian's point on that one, it's kind of that totality of the circumstances and going through the relationship of the parties in the back and the forth that is going to show your good faith throughout that and protect you from bad things happening to you later on. What we're describing right here, the explanations being given, the hearing out terms and whatnot, like that was about 50% for me on the union side. The other 50% was some degree of horror show. If there's another takeaway, don't be that, have a communication, have a relationship. It'll benefit you in the long run.
Heather, more questions? That's it. Well, thank you, everybody, for being here. We'll stick around. I'll stick around for a couple minutes if anybody wants to chat about anything else, but we appreciate it. Thank you.
Thank you.
Thank you.